16050, section 16050.
Where is it in the bill?
So there's really nothing in this bill that changes existing law that gives the DA the court's privilege.
Okay. All right. If we
Just the
look,
DA, rather, not the court.
yeah, if we look at first page, you go to line K,
First
keep
page.
going down, and now you have the new line part. So if you go to page 2, line 1, the penal law provided, however, that the record of such conviction does not demonstrate a conviction under subdivision 2, no defendant shall be required or permitted to waive eligibility for sealing pursuant to this paragraph. So what that's saying is, if I'm a district attorney, I'm looking at reducing the charges for you. However, I want you to waive the sealing. And what what that would do is you would have the original charge, and it would show that you pled to a lesser charge, and it would stay on the record. Okay? And that would be part of my plea negotiation as a prosecutor. Under this bill, and I think it even says it further on, if you read it, that it would be void. That it would be void if the DA tried to do something like that. Notwithstanding. Isn't that correct?
Okay. So, Mr. Graff, I'll repeat again. The DA can motion under existing law. And we quoted the number already once.
All right, let's try it.
16050.50.
All right, let's try it that way.
Okay.
So the DA can make a motion that it not be waived. I don't think I agree with you here because that's not what it says.
That not that it not be
But
waived,
if I'm
that
gonna
it not be sealed. The
All right,
DA
but-
can make that recommendation.
All right, but if the DA doesn't make a motion, it's automatically sealed. Right?
Yes.
And then it's up to the judge to approve that or not, correct?
The judge can approve it, and or the Department of Criminal Justice.
Okay. So now if I turn around and say I'm the prosecutor, I'm reducing the charges, and I'm saying, look, I'll reduce your charges, but it's got to be that the sealing is waived, right? I can't offer you that. That's up to the judge. Because I have to put in a motion to see if the judge will do that.
Okay, so I'm being advised by counsel over here that this is not asking to change existing law. So if you want to get a plea, then you have to look at using some law that's already in place. You cannot use this law that we're proposing here today.
Yeah, I've read, all due respect, I've read.
Subdivision 1 is not sealed.
Yeah, I read through the entire bill. Let me try this another way. All right? Now, if a person has marijuana in the open, okay, and part of your reasoning here is that the people are getting arrested for having marijuana in the open or burning marijuana, right? They're still going to get arrested, right? This bill's not going to prevent them from being arrested for that.
No.
And they're still going to be charged with a misdemeanor, correct?
Yes.
Okay. And how many bites at the apple did they get here?
Okay. They get one. The first one can be sealed. The second one cannot.
Yeah.
Within the charge. Well, he's a prosecutor. He understands that. The
Right.
first one can be sealed. The second one cannot.
Well, the thing is, though, according to this bill, if the records are sealed, and they're saying the court is sealing it in a way so that if you get locked up again for it, I can't see the first one because it's like you've never been arrested.
Well,
That's not what that says. Read the bill.
Okay, the records will not get sealed if the district attorney makes a motion
Ms. Walker, why
to
do you
have the
rise?
record remain unsealed, or the court on its own determination finds that the interests of justice require it to remain unsealed.
Ms. Walker, why do you rise?
Will Mr. Graff yield for one question?
Sure.
Mr. Graff will yield.
So, Mr. Graff, it seems like you want some explanation of the present law. Is that correct?
Excuse me?
Would you like to have an explanation of the present law around sealing or unsealing a record?
No, I want an explanation of what this bill is doing, because this bill is changing the sealing. Because right now it's not sealed, all right? This one automatically seals it, right? And what happens here is it even says it, you know, I can find it. It even says that the purpose of this is so that you cannot consider this, right, if the person gets arrested again for the same thing.
Can I
So it will-
submit one quick
Well,
thing?
let me finish.
Okay.
It won't show that the person was arrested for this. So the court won't know, or the DA won't know, that the person was arrested for this. Sort of like if you have a DWI, first offense, second offense is a felony, right? But if the record's sealed with the DA and they don't have, and they're not allowed to look at it, because what they're saying here is the chief administrator of the court shall develop and promulgate rules as may be necessary to ensure that no written or electronic report of criminal history record research
Right.
conducted by the Office of Court Administrator contains information related to the conviction for a violation.
Okay, I'm sorry, Mr.
So they're
Graff.
getting rid of any record of it. So now if the person gets arrested again, I can't turn around and see that to say he's going to be charged
I'm
with a
sorry,
second
Mr.
offense.
Graff. The reason why I made the request is because I wanted to clarify something for you. Presently, if a person is convicted, whether by plea or otherwise, that defendant can request the court to do an immediate sealing.
Okay.
It is up to the judge at that point to make a determination as to whether or not they will do so.
Yes, but under...
In many circumstances, some judge will say sealing after 60 days. Some will say, depending on the circumstances, we will do an immediate sealing. What I think this bill does is it provides an opt-out mechanism as opposed to an opt-in mechanism where the district attorney will have to request that there is no immediate sealing of a person's conviction record.
According to this bill, there's an automatic seal,
Exactly.
and that the
So-
person cannot waive it.
No, the
Right.
person cannot waive his eligibility to request an immediate sealing. So no defendant, no district attorney can ask a person to say, I'm not eligible for something that's already given to them in law. But what I want to point out to you again is that this is only an opt-out provision as opposed to an opt-in provision, because a defendant already has the right to make a motion to the court to request that his conviction be immediately sealed.
But that, you would agree that's very different than a person automatically having the record sealed, okay? Right? Then making that motion.
Well, I think now it just puts the onus on the district attorney to say, you know, we would prefer that this person's record stays open to the public.
Well, as
So-
a district attorney, I wouldn't be offering the plea bargains. So anyway, let's try this a different way.
Another question,
Excuse me?
Speaker?
Sure.
I want it to be clear that we're only talking about 25 grams or less of marijuana. We're not talking about a violent criminal. We're not talking about someone who has a consistent record of being arrested for marijuana or anything else. We're not talking about someone who's committed any robberies or raped or hurt anyone. We're talking about people, mostly young people, who have under 25 grams of marijuana.
Well, first offense.
And, Mr. Speaker, anybody can get access to these records under the Criminal Procedure Law 160.50. Under this law, for example, these sealed records shall be made available to a prosecutor, When a defendant is charged in a later marijuana case or seeks adjournment of contemplation of dismissal, they can be released to law enforcement agencies upon a motion to the court showing that justice requires release of such records. They can be released to a licensing officer or an agency when a defendant applies for a gun license. They can be released to a parole officer supervising a person when a record was sealed while the person was under parole supervision. They can be released to a prospective employer when the person applies for a job as a police officer or a peace officer.
Can I ask a
And they
question
can
on
be
that?
released to a probation officer
Yes.
supervising that person when the record was sealed while the person was under some sort of probation.
So we don't want
But,
law.
Mr. Speaker,
We don't want law enforcement. We don't want, if I'm applying for a law enforcement job, we don't want law enforcement to know that they have this conviction.
I said the records can be released to the list that I just read.
Okay.
Mr. Graff, you can come back for a second time.
Well, good. Thank you. Thank you very much.
Mr. Palumbo.
Thank you, Mr. Speaker. On the bill, please.
On the bill, Mr. Palumbo.
Now, just as someone who prosecuted these crimes, I was in narcotics for a while in Suffolk County District Attorney's Office, and I think when you juxtapose this, which is ultimately decriminalizing marijuana offenses, when you add that, when you think about the aspects of 17056 of the criminal procedure law, is an ACD, as it's called in the city, or an ACOD, an adjournment contemplation of dismissal in Suffolk County. Virtually every single time someone is charged with misdemeanor marijuana offenses, including sales, lower level sales, some courts require some drug testing or drug counseling letter, but virtually every single time in my almost 20 years practicing law, you get the adjournment and contemplation of dismissal. It's extended for 1 year. If you don't get in trouble in that 1 year, the case is dismissed. It's rendered a nullity by operation of 17056. By operation of law, we already have this provision within the penal code and criminal procedure law in New York State. So we just had on a previous bill, we had members talking about how e-cigarettes were a gateway drug to smoking, and now we're looking to decriminalize marijuana. So I think this is unfortunately a bad idea. I understand the intent of it, but this already exists within our law, and for those purposes, I will be voting no.
Mr. Goodell.
Thank you, Mr. Speaker. Would the sponsor yield?
Ms. Peoples-Stokes, will you yield?
Yes,
Ms.
Mr.
Peoples-Stokes,
Speaker, I will
Mr.
yield.
Goodell.
Thank you, Mrs. Peoples-Stokes. Can you give me an idea how much marijuana are we talking about? Are we talking about up to 25 grams? Is that correct?
Yes, 25 grams.
And can you give me an idea, since I'm not familiar with this, how much that is? I'm not asking you
I'm
to
not that
speak.
familiar with it either, Mr.
Yeah, I didn't mean to suggest that you would have personal knowledge, but perhaps you've been advised.
Less than a snack-sized bag, I'm being told.
I'm sorry? Oh, like a baggie?
Like a small bag, maybe, oh. How about this? Is it like the size of a tea bag? Okay. It's about this size, Mr. Goodell.
So the equivalent of like several cigarettes?
I'm not aware of that as well.
I think they use a
25 grams,
different term. I'm
sure.
not familiar with the other term either.
let's see.
But what, doobies? Joints?
No more than 2 cigarettes.
My concern is that, as you know, there are some occupations where the employer is very, very strict about drug use. Certainly, airline pilots is an example. Not lawmakers, but airline pilots, truckers, heavy equipment operators, manufacturers. And there's a lot of good reasons why they're very concerned, because obviously while you're flying high in a plane, you don't want your pilots high on marijuana or anything else. So with the automatic sealing of these records, don't remove that critical information from a potential employer.
Mr. Goodell, I would venture to say that most of those types of employers that you just mentioned will drug test employees prior to them hiring them.
And
And
so,
plus while they're hired. I mean, they do it randomly.
so the fact that they may have been arrested 2 months ago, you don't think should be relevant in an employment evaluation?
Not for 25 grams or less of marijuana, which I understand is 2 sticks, because you asked the question and a lot of people answered.
It took a while for us to find that answer,
Yeah,
but
well.
you know.
And you're not, no, you're not.
And I think the concern that Mr. Graff was expressing, if I might ask, it's my understanding, by the way, he's a criminal defense attorney. And once in a while, I dabble in that field. Most of my clients are law-abiding, of course. But,
Of course.
of course, the problem that criminal defense lawyers have is that they're always trying to get the district attorney to agree to a plea bargain. And the concern is that if a reduction in the plea brings the offense within the section and it results in an automatic sealing, the district attorneys will be simply unwilling to allow our defendants to plead to a lesser charge. How do you address that concern?
Okay, well, I've just been handed a law book. And according to Penal Law 221.10, criminal possession of marijuana in the 5th degree, you can,
If you plead to number 2, it's not sealed.
okay. If you plead to number 1, it could be sealed. But if you plead to number 2, it cannot be sealed.
Well, the concern is
And
that you're
That
pleading.
I'm sure the DAs understand. They probably don't even need to be handed this book.
So if you're, for example, arrested for violating not Penal Law 221.10, which is limited to 25 grams, but say 221.15, which I think goes up to 2 ounces. Am I correct? Now we're starting to talk about a lot of joints.
That is not covered in this bill. It's 25
Right, and-
grams and under.
And so the problem that a criminal defense lawyer has is if your client's been arrested for having a lot of joints, the DA may not be willing to allow you to plead to a lesser charge if there's an automatic sealing. So aren't
Well-
we resulting in more
Say that again.
defendants receiving a higher charge? I mean, doesn't it kind of
So-
defeat the purpose of this bill?
I'm being told if they just plead to number 2, it won't be sealed. And
No, I'm talking about 211.15. You're arrested for 211.15. This will make it almost impossible to plead to a lesser charge of 211.10.
okay, it won't be sealed, Mr. Goodell. If they use that section of the law, that's like the second time. It will not be sealed.
Thank you for your comments, Mr. Peoples-Stokes, on the bill.
On the bill, Mr. Goodell.
Sometimes we have good intentions with unanticipated consequences, and such, I think, is this bill. Good intentions where a defendant may have a very small amount of marijuana, and I believe the sponsor's desires that that's sealed so it doesn't affect their future. The problem is when you have a remedy that the district attorneys don't like and don't support, what happens is the district attorneys that might routinely allow a reduction in a plea will refuse to allow the reduction. And that problem is made worse by this bill because under this bill, the language of this bill expressly prohibits a defendant in the context of a plea agreement from waiving the sealing. So even if the defendant wants to get a reduction in the charge and wants to waive this right, he can't do it under this bill. So that's the first unintended consequence. It makes it much, much more difficult for a defense attorney to actually negotiate a lower plea agreement. The second concern that I have is that if you're an employer and you're hiring somebody in a job that requires them to maintain sobriety and not be on any drugs, including marijuana, because of the nature of their work. Over-the-road trucker driving a vehicle that weighs several tons and it's going 60 or 70 miles an hour, or an airline pilot, or an individual who's operating heavy machinery. It is absolutely relevant for the employer to know that this individual was arrested for smoking dope or having some other marijuana possession. So there are unanticipated consequences. Right now, in New York State, of course, you can apply for sealing, and if the court believes it's in the best interest of justice, they can grant it. And we routinely seal records for young kids under the age of 17, youthful offender status. And we understand that. But this takes it one step further and says, you can be high or have substantial amount of marijuana, and we automatically seal. And I don't think that's the right step from a public safety perspective, nor even the right way to deal with the complexities of the criminal justice system as it relates to plea bargaining. So while I appreciate the sponsor's desire to show compassion for individuals who have relatively modest amounts of marijuana, I think the ramifications are much more serious and probably more negative than anticipated. For that reason, I would not support this bill. Thank you, Mr. Speaker.
Thank you, Mr. Goodell. Read the last section.
This act shall take effect on the 60th day.
Clerk will record the vote. Mr. Rodriguez to explain his vote.
Thank you, Mr. Speaker, for giving me an opportunity to explain my vote. I'd like to thank the sponsor of this legislation for what is truly important in terms of thinking about unanticipated and unintended consequences. Let's reflect on the unintended consequences of sending tens of thousands of people through the criminal justice system for what should be a violation. And as a result, closing doors, opportunities, educational, and work opportunities for tens of thousands of disproportionately affected black and brown people in low-income communities who are suffering for an over-policing in our communities. Suffering not just for the last 5 years, but literally moving forward, because we have not been able to decriminalize what is a minor amount of marijuana, and we still are continuing to prosecute tens of thousands of people in the same way. So I think this is a step in the right direction to making sure that we don't continue to close the doors of opportunity for those who continue to need those doors open, and to make sure that we are treating everyone fairly. And we know that that has not historically happened in our communities. So I want to thank the sponsor for this legislation and urge our colleagues to support it.
Mr. Rodriguez in the affirmative. Ms. Richardson.
I rise in support of this piece of legislation. For far too long, there's been a disparity in minority communities where minor amounts of marijuana, possession of that amount would result in you having a misdemeanor that is preventing you from having access to higher education, access to gainful employment. I often speak to many individuals in my district, and they have these roadblocks and these barriers for these minor infractions that they committed some time ago, yet we as a society do not look to give people second chances. So, Ms. People-Stokes, you are courageous. Thank you for putting forth such bill, and I vote in the affirmative. I don't know. I was like, I'm done.
Ms. Richardson, you want to continue?
No.
Okay. Gremlins in the system. Mr. Barron.
I want to commend the sponsor for this bill, because we know that justice is not blind, not in this neighborhood, not in this country, not in our communities. There's two justice systems, one for other people and one for just us. So we appreciate what you've done, and we appreciate the fact that you understand that a minor infraction like that can destroy a person's life. And I know they come through hypotheticals about people being on planes and smoking, but that ain't even real, because that's not what really this bill is all about. I don't think any airline would hire somebody like that. They have their own policies for checking for drugs. So it wasn't about much that was in this debate. It was more about the reality that a lot of our young people their futures are destroyed for these minor infractions, and this is an opportunity for them to have an opportunity in life to move ahead like everybody else and have a decent opportunity for places to live, for employment, for schooling, for a whole lot of things. And you'll be shocked and amazed about how many of our youth, black and brown youth, are caught up in this system, afraid to put on a employment application that they've been arrested for a little amount of marijuana. If they put it on there, then they don't get the job. If they don't put it on there, then they are lying and get fired if they do get the job. So until we get rid of that box and some other kinds of things, I commend you for this piece of legislation. I vote in the affirmative.
Mr. Barron in the affirmative, and you guys are on my stopwatch. Mr. Lenthal to explain his vote.
Thank you, Mr. Speaker. Ladies and gentlemen, this law that we're seeking to amend is a very old law. Let's face it, marijuana has become legal throughout the country. In many places, in many forms, whether it's medical marijuana. I didn't want to get into all of that because most of my colleagues have explained how this can hurt an individual for the rest of his life. But I just wanted to point out one of the provisions that was discussed in this bill but was not very clear based upon the arguments on the other side of the aisle, in which they clearly did not understand the implications of waiver at a plea agreement, waiver of this provision of sealing. What that would mean is, and in practical effect, is that if you're in court and you're before the court, the district attorney does not take your plea unless you agree to waive your right to a sealing. What good does that do an individual who wants to live a life later on and have that record exposed forever? It defeats the entire purpose of this bill. And you know very well that prosecutors are well equipped to say that we won't give you a lesser plea in any case if you don't agree to waive the sealing. Very important provision. It's not unintended consequences of this bill. It is the intended consequence that we put it in the bill. I vote in the affirmative.
Mr. Lenthal in the affirmative. Mr. Levine.
Public defender in New York City in the early 70s, early to mid 70s. Many people were brought into court. Many people left court with criminal convictions for possession of small amounts of marijuana. By 1977, what had occurred was that it wasn't just the children of the disadvantaged who were getting these convictions. It was the children of judges. It was the children of prosecutors. It was the children of state senators and state assembly members. This legislature responded in 1977 by doing its best to take marijuana out of the criminal law to the extent that people would no longer get convictions for possessions of small amounts of marijuana. Now, I heard, it's a long time since I've handled any cases involving marijuana, but what I heard here today from some of the prosecutors was that, well, they think it's perfectly fine to use this sealing mechanism as a bargaining chip with the defendants. That's not fair. That's not what the legislature had in mind going back almost 40 years ago. This is a good bill. This is going to protect young people from getting convictions they don't need to convict. Our prosecutors and our police have got a whole lot more important challenges to meet and master than processing young people for possession of small amounts of marijuana. This is a great bill. I'm happy to vote for it.
Mr. Levine in the affirmative. Ms. Walker.
For allowing me the opportunity to explain my vote. Clearly, this is a day of vindication for the countless number of New Yorkers who have been subjected to the injustices of our criminal justice system and its procedures. There are too many occasions where we would request an immediate sealing because a person who was arrested was a teacher, for instance, and would have to go on leave for 1 year if they did take the ACD that was offered to them, if it was for the extent of a year. And many times when we bring up the importance of immediate sealing so that people can go on and live fruitful lives and take care of their families and their communities, we would be told, go and speak to your legislature if there's something about what we're doing that you don't like. So today, I am speaking to our legislature as a member of this body to say it is our time to act on behalf of the thousands and tens of thousands of New Yorkers who are subjected to these injustices each and every day of their lives. It's time to say that they can go to school and obtain Pell and other grants so that they could be eligible for loans as well, for them to go on and go to college, to say that they can obtain the type of employment that they really deserve so that they can go on to be fruitful members of our community. So I think that we should stop this cutting off of opportunities for our people in our community, particularly young people, and do this bill today and make sure that it becomes law not just here in the New York State Assembly, but we also carry this over to the Senate and to our executive chamber to say that the time to do this is now. So thank you, and I proudly vote in the affirmative.
Ms. Walker in the affirmative. Ms. Peoples-Stokes.
Thank you, Mr. Speaker, for the opportunity to explain my vote. I want to thank my colleagues who understand the value of reinvesting in a lot of young people who have done nothing more than many other people in this country have done. And they deserve an opportunity. And this bill just simply asks that we would have their records sealed, and if they don't take advantage of the opportunity that's being presented to them here, and they decide that they want to go off and do things that are not right by this society, then our courts and our systems have a way to call that back in and unseal those records. But I believe that there are a number of young people out there who really feel like they have nowhere to turn because of what they did a year ago. And we need to provide them that opportunity. This is what this bill does. To say you do have somewhere to turn. There are opportunities for you in this country, and we're going to help make sure that that happens for you. So I want to applaud my colleagues who are voting in support of this legislation and say to my colleagues who think that it's still a no vote, is you just don't understand. You don't understand how people's lives have been destroyed because they smoked the joint. And other people who smoke the same joint, lives are full. You just don't understand.
Ms. Peoples-Stokes in the affirmative. Are there any other votes? Announce the results.
Ayes 92, noes 34.
The bill is passed. Mr. Morelli.
Yes, thank you, Mr. Speaker. First of all, let me ask members of the Governmental Operations Committee to proceed to the Speaker's conference room. Ms. Peoples-Stokes is now available for that, and we'd like to accommodate those members. And before I go to the next series of bills that I'd like to take up, I'm delighted to be able to introduce a special guest to the Chamber this evening. Our colleague, Dr. Leonardis, has his beautiful daughter, Myra Linares Garcia in the chambers. She was confirmed this afternoon as a member of the CUNY Board of Trustees, and she's a great friend and known by many in the chambers, and we're so excited for her. In addition to her impending new job, she's an impending new baby girl in another month or so, so she's excited to have that. We're excited for her. Want to wish her every good fortune in the future. If you could please extend the cordialities of the House.
Certainly. On behalf of Mr. Linares, the Speaker, and all the members, we welcome you here to the New York State Assembly. We extend to you the privileges of the floor. You are family, always welcome here. We're so proud of you, and we'll share in the expected joy. A new job, a new baby, you can do it all. Thank you so very much. Mr. Morelli.
Thank you, Mr. Speaker. I have another series of bills I'd like to take up in this order, if we can. The next bill I'd like to take up is on calendar number 820 on the main calendar by Ms. Gunther, and I can give you the page number in just a second. Calendar 820, slate on page 89, I apologize. Page 89, calendar 820, Ms. Gunther. We're going to follow that with Rules Report 130 on page 9 by Mr. Lenthal. Then I'd like to go to calendar number 718 by Ms. Simonis, which is on page 80 of the main calendar. Those four bills, I'll give you further direction after we take care of those four. You're right, it's three bills.
Right.
And yesterday I said the Bills went to 5 straight Super Bowls, so I'm
New
clearly
math
having
is
difficulty
difficult.
with numbers under 10. Thank you.
Clerk will read.
Senate 6987, calendar number 820. Ms. Gunther, an act to amend the tax law.
On a... Oh, it's been said? Explanation is requested, Ms. Gunther.
This bill would increase the number of counties in which services can be performed to qualify for an additional 10% Empire State Film Production Tax Credit.
Ms. Corwin.
Thank you, Mr. Speaker. On the bill.
On the bill, Ms. Corwin.
Back in the enacted budget of 2013-2014, we created this Empire State Film Tax Credit, which was intended to last 5 years. Since then, we've gone back and added or modified, I think, 3 more times since then to increase the number of counties that can participate in this program, as well as bump up a little bit what the opportunities would be for them. The original number was $420 million, of which up until the timing of this bill, we've only used $233 million. Some people might think that's a good thing. Some people might think it's a bad thing, depending on which side of the aisle you're sitting in, quite frankly. I, being a business person, am very much in support of tax breaks. I think whatever we can do to support businesses in the state certainly benefits the residents of the state. However, I think it's important at this point to take notice of the fact that it is such a huge tax break, $420 million. It's so big that we haven't even been able to give it all away yet. And what's concerning to me is that at the same time that we hit that $420 million number in the budget, that same budget cut funding to OPWDD by $120 million. Just think what it would have been like for those people, for those the developmentally disabled in the state who had all of their services cut, while at the same time we're giving so much money to people like Jimmy Fallon's television show that was in LA to get them to come back to New York. And so I'm very frustrated by the sense that we keep coming up with ways to do this